It is a real treat for us to have with us today both Dabney Riordan and Dabney and Adam Aderton. As John said, Dabney and Adam are co-heads of the Asset Management Unit of the Division of Enforcement at the SEC. And together, they have about 30 years of experience at the SEC. So it's going to be great for us to get their perspectives. Welcome, Dabney. Welcome, Adam. So, Dabney, why don't we jump right in and start with you? Can you tell us a little bit about what the Asset Management Unit is, and in particular, how the agenda of the unit is set and how the unit fits in more generally with the Division of Enforcement?
Absolutely. And let me just give the same disclaimer at the very outset for both Adam and me that the statements we make today are our own and do not the views of the Commission or any of the Commission's other staff. And with that said, so the Asset Management Unit, as I'm sure many folks know, is a specialized unit that was formed 11 years ago. Adam and I are both actually original members of the AMU when it was first formed. And it is a host of staff attorneys, industry experts, and paralegals that are devoted to looking at management violations by investment advice, part that we focus on. And so that leads us to, we generally look at advisors to separately managed accounts, to registered investment companies, and to private funds. And so we generally do evaluate. Adam and I talk regularly about where our priorities are and where the unit's priorities should be. It's not as formal of a process as you saw with the exam program, but it's definitely something that Adam and I look at. It is where we focus, again, the separately managed accounts, registered investment companies, and private funds, and try and identify what the key risks are in those areas in terms of an enforcement perspective. And that can come from, what we're hearing from exam, from what they're observing and what they're referring to at the enforcement program, complaints that we receive from the public, and certain, even if it's in news articles and things like that. So we work there with that information to truly try the key risks and focus our cases in that space. Generally, how cases work is we have folks all across the country in most of the regional offices and in the home office, and each case usually has an attorney, an assistant director, and an industry expert assigned to it. Our industry experts are very important. As their name implies, they come from the industry and they provide us a lot of guidance on how the industry functions. In general, Adam and I, as with other specialized units, we report directly to the division director. Right now, that's acting director Melissa Hodgman. And we work with the regions throughout the country, both in terms of our own cases as well as consulting on cases outside the unit that involve investment management issues.
Thanks, Dabney. That's helpful background. Adam, let me ask you, we are in a period of transition right now. Does that change the work of the division? And if so, how?
That's a great question, and thanks for having me here, Gail. It's nice to have a chance to talk with you and your members. I guess you're totally right that we're in a time of transition. Chair nominee Gensler had his confirmation hearing earlier this week, and so we've had one chair change. I think the press reports say we're likely to have another chair change. As Dabney mentioned, we have an acting division director right now, and so there are a lot of changes at the top. But for the vast majority of the staff and the enforcement staff, we're all still here, and we were here before, and probably several of us will still be here later. And so our work, doesn't change as much. We're still focused on the same things that we've been focused on throughout the 11-year existence of the unit. So we're still focused on conflicts of interest, and we're still focused on fee and expense allocation issues, and we're still focused on the same valuation issues that we've always looked at. A couple of things that maybe are a little bit different, as you talked about with Pete, and as we've sort of seen in the release of Pete's priorities and elsewhere, there is a greater emphasis on certain aspects of what we're looking at, for example, on ESG, which we may talk about a little bit more later today. And then there are also sort of subtle changes in the way that the division operates. For example, there's been a delegation back to senior officers like Dabney and me for the ability to grant the authority to issue formal orders, which is a change from the past administration, but returns us to the previous administration. And I will tell you that in the 12 years, 13 years I've been at the SEC, I don't know that I've ever had significant difficulty getting a formal order, but this is just sort of a change that we can see that is a slight change to our procedures.
Well, Dabney, let me follow up with you. What is the process of going from a referral from exams to the division to your unit, and how does it become a formal order?
Fair question, but I always like when I get this question, I like to point out it is the exam that ultimately leads to an enforcement referral. So even if a firm gets a deficiency letter, they should not think that that automatically means that it is going to be referred to enforcement. They should the deficiency letter very seriously. I know exam spends a great deal of time and care in drafting those. But if we get a referral, it's again a limited number of cases, and it's usually an issue that is tends to be more serious among other deficiencies than exam notes. And when exam decides to do that, they will reach out to enforcement, and we start a discussion about what the issues are that they're observing and why they are so critical, and why enforcement may be interested in conducting an investigation to look further into the issues. And when something becomes an enforcement investigation as opposed to an exam really varies. And it can depend on a lot of different factors. Sometimes there's a lot of concern about, there's a certain amount of exigency because there's a potential issue of dissipation of client assets, or there's a potential issue with a statute of limitations that's upcoming. And so that may require that the matter be referred to enforcement much sooner. But overall, the exam process more frequently than not completes itself, and then enforcement will evaluate whether or not we are going to look into it. And then whether or not that leads to, not all investigations ultimately have a formal order, even if they result in a recommendation to the commission. Whether or not we get a formal order is an assessment of whether or not subpoena authority is needed, and would help streamline an investigation. But a lot of cases actually go to completion without a formal order, and we do make recommendations still to the commission.
All right, so that's the scary part out of the way. Thank you for that, Dabney. Adam, let's drill down a little bit into investment advisor issues. What are you seeing lately related to investment advisors that's raising concerns?
Sure. So a lot of this overlaps with some of the things that Pete talked about in your prior conversation. So we continue to be very focused on disclosures related to conflicts of interest that advisors may have with respect to retail clients, and really with respect to any clients. But we're still seeing instances of undisclosed or inadequately disclosed revenue streams. And so we're continuing to bring those cases and sort of looking across revenue streams to make sure that there's adequate disclosure for each of them. On the fund side, we're pretty focused on valuation issues. We're focused on some of the side-by-side management conflicts that Pete was talking about. We're still focused on the allocation of fee and expense issues, the types of issues that we've often seen in our private equity fund cases over the last several years. And then one other place where we're looking, not an exhaustive list, of course, but one other place we're looking is at investment strategies that are inconsistent with disclosures. And I'll just make a note that I think it's possible that that's maybe where ESG is going to fit in the first instance in an enforcement context. But one thing I do want to mention, we are still looking, we are starting to look at issues that came out of the Reg BI rules package back in 2019. So that includes not only Reg BI on the broker side, but that includes the fiduciary interpretation and the Form CRS, some of the other things you were talking about with Pete. That's on enforcement radar as something that we're looking at.
Right, thank you. That's helpful, if not happy making. Let me go to you, Dabney, and talk about the impact of COVID and the pandemic. What kinds of things are you seeing that are something that enforcement should be weighing in on or bringing actions relating to?
So the work environment, I know, created a lot of new challenges for firms, and that a lot of people were working remotely. And then obviously that created new challenges in terms of the obligation to protect PII, making sure that your policies actually matched up with how your work environment currently was or was functioning. Making sure that you're doing the monitoring that you're supposed to be monitoring. I believe either you or Pete acknowledged earlier that the amount of digital communications has really expanded during this period of time. Books and records, and that those are being maintained and things like that. Me personally, I do not foresee this being a major area of enforcement for the commission going forward. I think, as Pete said, a lot of firms reacted well to the new environment and making adjustments. And this is not a situation where the goal is to play gotcha. We want firms to take an honest look at what changes needed to be made in light of the new environment and to make those changes in light of those risks.
So, Dabney, Adam mentioned conflicts, and I'd like to circle back a little bit to the Shareclass disclosure initiative, the Shareclass selection disclosure initiative. What is the status of that initiative and the follow-ups from that initiative?
Okay, yes. So that initiative was initially announced in February of 2018, and last year the commission announced that it had instituted the last orders against firms that self-reported as part of the initiative. So in terms of firms that self-reported in compliance with the requirements of that initiative, those cases are done. And as you noted, we have been focusing efforts on identifying firms that were eligible to participate in that initiative but did not do so. And there have been a series of cases that the commission against firms in terms of a litigated context and a settled context, that firms that had an opportunity to self-report and did not self-report, where they received 12B1 fees and there were lower costs, and either they didn't disclose that conflict or they didn't disclose that they would pick a 12B1 fee when a lower class was available. In those cases, speaking to the settled cases more than the ones that are litigating right now, the disclosure problems varied, as can be seen in those orders. It would be sometimes there was some disclosure and it was inadequate, but there were also cases where there was absolutely no disclosure about the receipt of the 12B1 fees, or there were affirmatively misleading disclosures that were being made to clients. And one other thing to note that has come from those cases, well, just to back up a little bit and to flag for you that there was a firm that did self-report. They self-reported late. They otherwise provided all the relief provided for under the initiative. And the commission instituted an action against that firm, but the penalty was notably lower than some of the other firms that did not self-report, and they have been receiving slightly higher penalties than those that were received historically. One other thing I wanted to note is that a handful of those cases also have issues separate and apart from the receipt of 12B1 fees and that conflict of interest. Those cases have also included undisclosed or inadequately disclosed conflicts of interest regarding revenue sharing from mutual fund selection or from cash sweep selection, and undisclosed conflicts of interest in connection with the ability to avoid paying transaction fees and client wrap. The mutual fund share class issues really go beyond the 12B1 fee space, and those cases are reflective of that.
Right, thank you. Adam, there's been quite a lot in the press about payment for order flow, and just sort of generally a lot of the moves to zero commissions. Can you just touch a little bit on that, and to the extent that you can maybe focus on why it's important for advisors rather than just broker-dealers.
Sure. So, so payment for order flow and the rules around payment for order flow, I'll start by staking out the ground that what the rules are is not really enforcement's issue. And I know that there's a lot of talk about what the rules should be. You know, I'm eager to enforce whatever rules folks have now and whatever they come up with in the future. But from our perspective, for advisors, for brokers, really for anyone, if your client or your customer, if their orders are going to be sent to an internalizer or you know, otherwise processed that way, and you know that, and that's a form of compensation that you are somehow going to get or an expense that you're going to avoid, what we're going to be looking for is as in most other cases, and it actually goes back to something you said in your conversation with Pete, you know, say what you do and do what you say. And so if it's going to have an effect on the client, just be clear and follow through with that, because if you're going to have cases, that I think is where you're going to run into problems. Cases where clients are unaware that it's a revenue stream for you, or clients are unaware that their orders are being executed in a way that may not give them the execution that they were expecting.
So thank you. Also following up on, you know, Pete was talking about in the private fund context, some of the conflicts that exams are looking at. And, you know, Dabney talked about the Shareclass selection initiative. Are there other conflicts in the advisor space that you think it's worth talking to this audience about and having folks be aware of?
I do, and I think some of those conflicts we see often in, for example, in the private equity context, where there are fees and expenses associated with a transaction, and multiple clients participate, or the clients and the advisor. It's unclear who is going to bear the responsibility for those expenses associated with that transaction. Those are situations where, again, we would, I think, expect you to be consistent with your documents, very clear with the client funds, either through the LPAC or in some other way, about what those expenses were, how they were allocated, and how that was consistent with the LPA. So that's a specific example of the conflicts that can come up in side-by-side management when you have multiple clients participating in the same transaction. We also see conflicts associated with a situation where there's a third-party service provider or services that could be performed by a third-party service provider but are being provided by, say, a captive service provider, something like that. We just want to make sure that it's clear to clients and it's clear to investors in a fund if those costs you know, are in addition to the management fees and other fees that the fund investors and that the fund expects to pay, or, you know, would have expected to pay when they entered into the agreement. So those are two issues that we have seen recurrently. We have past cases on that, and it's something that we're still interested in.
Great, thanks, Dabney. Can I circle back with you just a minute on Shareclass selection and 12B1 fees? A couple of questions have come in through the chat. I think one seems to be getting at, is the concern really more generally about 12B1 fees, regardless of whether or not there's sort of adequate disclosure and even when neither the advisor or an affiliate receives fees? And I think the other question is sort of getting to, are you looking at situations in which the advisor did not receive 12B1 fees, but they went to the unaffiliated platform provider?
Okay. Yeah, those are very fair questions. So I'll take the second one first, because there is some nuance to that. So where the fees go to the platform provider or anything like that, if there is a benefit that the advisor is otherwise getting from picking those share classes that is not necessarily the receipt of the 12B1 fee, then there still remains a conflict of interest. So that is something that we've observed where, and again, I'll use the example of the avoided transaction fees in a wrap account. The platform provider may say, if you pick these certain mutual funds, you think that's more expensive, or something that pays a 12B1 fee to the platform provider, We won't charge you a transaction fee, you, the advisor, a transaction fee, and you have wrap arrangements with your clients. That is still a conflict of interest, even though you don't necessarily receive the 12B1 fee. You are getting a financial benefit from making that selection for your advisory clients. Separate and apart from that, in terms of if there really is no financial benefit to the advisor in terms of additional revenue or avoiding a particular expense, there is still an advisor still has an obligation of best execution. Sorry about that. They still have an obligation of best execution. And so we have seen instances where the advisor didn't get any of those financial benefits, still picked a more expensive share class for their clients, whether or not it paid a 12B1 fee, and that's what made it more expensive. A share class can be more expensive for other reasons. When there was a more favorable share class available for the clients, then that is a violation of the advisor's obligation to provide best execution for their clients. And we have seen instances. There was a case from several years ago where two were charged in the same order. One was charged because they gave the instruction to a sub-advisor to the more share class, and there was a conflict of interest there. But the sub-advisor was also charged because they were not, by following that instruction, they were not providing best execution to the advance.
Yeah, so we've definitely seen, following the initiative, I think all the cases that I've seen have had a best execution component to them as well. So that's been an interesting development. For those firms that participated in the initiative, is there going to be a closeout letter?
When we conduct an investigation and we decide not to recommend action to the commission, we will to certain parties that may either request it or may naturally think do an action, what's called a termination letter. I think a closeout letter may have been more what an examination term. So we will provide a termination letter. However, if we recommend charges and there's an order, then that's pretty much the conclusion of the investigation, and there's no termination letter sent.
Great. Thank you for that clarification. Let me just give everybody the second continuing education code word. It is enforcement B. That's one word, enforcement, capital B, no spaces. Let's turn to material non-public information. And Dabney, I'd like to stay with you for this, if that's okay. There have been a few cases recently that focus on MNPI. What kind of issues for advisors are you seeing related to MNPI?
Right. So there is a special section just for dealing with procedures by advisors. And that is separate and apart from the 20647 obligations to have policies and procedures to prevent violations under the Advisors Act. And the recent cases have found violations of 204 Cap A, which is the provision that requires the policies and procedures to protect MNPI. Those really fall into deal with issues where the policies and procedures that the firm had were inadequate. The firm did have some policies and procedures. They just were inadequate in light of the business that the firm engaged in and their access to MNPI, and then also the failure to implement those policies and procedures. And for me, I think the takeaway is that you really do have to have policies and procedures, and this applies both to the 204 Cap A cases as well as to even more general cases, but you have to have policies and procedures tailored to your business. A cut and paste methodology of coming up with policies and procedures is really a big risk for firms, and that they should really evaluate and talk to the people internally and what MNP have access to, and make sure they prepare their policies and procedures consistent with the frequency of access to MNPI, how much NPI they do, and really make sure their policies and procedures risk, and then also that they make sure that they're implementing those procedures in a consistent way.
Right, thank you. Adam, we talked a little bit earlier about ESG, so let's kind of come back to that now. The next chair nominee, Gensler, it's hard to know how to describe that, and acting chair Lee have both highlighted ESG as an area of focus, obviously. So what potential issues for advisors do you think could arise in connection with ESG investing?
Yeah, it's a good question. I think there are a lot of potential issues here, but I think that the potential issues that go with sort of any investment style, at least in the first instance, from an enforcement perspective, so not speaking from a policymaking perspective, but from an enforcement perspective, I think that your earliest cases are going to be situations where firms purported to have an ESG methodology and didn't implement it, or advertised an ESG methodology, and that was inconsistent with their actual practices. And in that vein, I think ESG is sort of another investing style, and we've seen those kinds of cases before where firms have said we're going to follow a particular strategy in our investment process, and then we've brought cases where it turned out that they didn't. I think that's what you're likely to see for ESG in the first instance.
Okay, great. Well, let me let you close out, Adam, because we only have a couple of minutes left. The top of mind for this audience is CCO personal liability. So can you basically tell us what you're looking for, particularly in that third bucket, and I'll leave you to sort of describe the buckets. And if you can leave us with some practical takeaways for CCOs to try to mitigate personal risk.
Sure. So I know this is an important topic. We certainly recognize for CCOs that the prospect of personal liability is a real concern. The prospect for personal liability in any line of work, I think, is a real concern. So it's not a surprise to us. Our cases have really fallen into three buckets. They've been described different ways. But the first big bucket is CCOs who affirmatively participate in misconduct, maybe because they wear multiple hats, or maybe because they're only in the CCO hat, but they're engaging in the fraud. Nobody seems surprised when we charge those people. I don't think that's a real concern. The second concern is the second bucket of cases are people who deceive or tend to deceive the SEC, either exams or enforcement or both. Again, that's sort of backdating documents or fabricating documents. I don't think anybody has a real deep concern for those folks. Either. That makes sense as an enforcement case. The third bucket has been described either as a wholesale failure or a failure to meaningfully implement something for which a CCO is responsible. And those two buckets, or in that bucket, that third bucket, I think that the way to sort of mitigate your liability or potential liability there is to sort of document what you've done, and to do what your policies and procedures have said that you were going to do. The most recent case that arguably falls into that bucket is a case called North, where the SEC upheld a FINRA suspension or upheld a FINRA enforcement action, and then that was upheld by the DC Circuit. In that case, there were a number of red flags that the CCO did not follow through on. The most notable, 85% of the firm's communications were Bloomberg messages, and there was no monitoring of Bloomberg messages. So from our perspective, that's a failure to meaningfully implement. That's a case that potentially we're going to bring. So I would say document. I would say go to the business people and advocate for resources where possible. We've tried to put out cases, and Pete certainly has put out statements saying we expect CCOs to be empowered and to have authority. Take those documents to the business people and say, look, the SEC is looking at this. And in particular, take the Pennant case if you really need one, because in Pennant, the CCO tried to get more resources. CCO wasn't charged, but the principal of the firm who sort of deflected all of those pleas was charged.
All right. Well, thank you, Adam and Dabney, both of you. It's been a treat to have both of you here.